we're all here in this courtroom today. Once again, the burden is on the state of Ohio to prove his guilt of these charges. And if you were asked to go back in that jury room right now and start to deliberate on what the verdict ought to be, whether that's guilty or not guilty of either or both of these charges, your verdict would have to be not guilty. Can you all accept that? And that is because there has not been one bit of evidence presented to you at this point. You can't make a decision until you've heard all the evidence and then heard the law that Judge Shanahan would tell you at the end of this case that applies to the evidence that's occurred in this courtroom. And then you go back and you start to deliberate. Another right that defendants in America are granted is what's called the right to remain silent. That is, Ray could, from the day this first happened right up through the end of this trial, not say a word about what he's charged with. And Judge Shanahan would instruct you that you can't hold that against him. Does anybody have a problem with that concept? Anybody feel like Ray has to get up here and testify? Okay. That's a question that was addressed again in these questionnaires. It was not a very well-worded question, or maybe it wasn't exactly the right question, but a lot of you indicated some confusion with that, I think. A lot of you felt like he had to testify. A lot of you gave indications that you thought that he ought to be allowed to testify if he wants to, like maybe you thought he didn't actually have a right to testify if he wanted to. Ray has an absolute right, and the judge would tell you at the end of this trial, if he does not testify, that you can't hold that against him or make any kind of determination about his guilt or innocence in this case based on whether or not he testifies. Are you all willing to accept that? Okay. That's kind of a test for you, because if any of you indicated that that was a problem for you, that you couldn't be fair and impartial, if he didn't testify, you were going to hold that against him, that means you are basically not qualified to sit on this jury because you wouldn't follow the judge's instruction that you can't hold it against him. I will tell you right now, Ray Tenzing will testify in this matter because he wants you to know exactly what occurred on July 19th, 2015. So that was just a test to see if anybody says, I'm going to hold it against him. Y'all passed. Mr. Gibson indicated during his questioning that there will be some photographs from the coroner's office here, and you all indicated, and I'll tell you right now, they're going to be pretty gruesome. You all indicated that you could look at those and that would not be a bother to you. I'm sure it's going to bother you, but that you could do that as part of your duties as a juror. Am I correct with that? There's also a video. On July 19th, 2015, when this occurred, and I think most of you indicated on your questionnaires that you've read and heard about this case, and some of you have seen the video, or most of you have probably seen the video. Ray Tenzing was wearing what's called a body-worn camera. That's a little camera that was affixed to his chest, which recorded this entire incident, which, by the way, the part of the video that brings us all here is probably about 2 seconds or less. And we're going to spend probably 2 weeks talking about it. In any event, that video is also very graphic. And I'll tell you right up front, you're going to see a man die in that video. Is there anybody who feels that they could not participate in this trial just knowing that that's what's going to come? And I see you all looking at me like I assume your silence means you can do it if we ask you to sit on this jury. Okay. Would you all agree with me that a video camera worn on a chest is going to show what the eye of the camera sees? And it's not going to show you what the eye of the person wearing the camera sees. It's not going to tell you what the person wearing that camera perceives in his brain or feels in his gut. It's simply one piece of evidence. Would you all agree with that? And I will also tell you that this video, it's not like Mr. Gibson mentioned the Bengals game yesterday. It's not like an NFL football game or the World Series where they've got 10 cameras looking at the same thing from 10 different angles. This is going to be one video, very short, very choppy, very fuzzy in points. So are you all willing to, again, agree that we'll look at the video and consider that as one piece of evidence, but it's absolutely not controlling? We got to hear everything, see everything. Everybody's in agreement with that? Okay. And again, at the end of the case, Judge Shanahan is going to instruct you on the law that will apply to the evidence that's been admitted and the testimony you've heard. You're all willing to accept the law that she gives to you, correct? Okay. Even if you disagree with it or don't think that's the way the law ought to be, you're willing to accept it. That's part of your oath. Okay. We've talked about the length of the trial potentially going to November 18th. Again, none of us can imagine it going that long, but you know, our 10-minute break a little bit ago turned into 45 minutes. A lot of what you do as jurors, I like to refer to as hurry up and wait. But Judge Shanahan has indicated that we're going to go every day from 9 to 1, so I anticipate that we won't have a whole lot of delays like that, and once we whittle the number down to an actual jury, things ought to move a whole lot quicker. So I think November 18th is unrealistic, but again, if it should for some reason, and I've tried a lot of cases, and you never know what's going to happen during the course of a trial, so if for some reason this trial does go till November 18th, is there anybody that feels that that would cause them great problems? And I know, sir, that you've indicated you've got a problem, and we'll deal with that later. One of the other things, and I think Mr. Gibson alluded to this, is that once we get a jury, the first thing we're going to do is go view the scene. We're going to go right up Vine Street Hill here to Thill Street and to Rice Street on a bus and look at where this happened, and the bailiff, Mr. Knoll, is going to point out certain things to you during that view. I think it will probably involve you all getting off of the bus and walking a little bit. Not much, but a little bit. Is there anybody who has any physical problems that would prevent them from getting out and walking a short distance? Okay. One of the questions on the questionnaire dealt with people, whether you have any affiliation with the University of Cincinnati. And I know a number of you are either former students at the University of Cincinnati, you've got kids that go there, relatives that go there. Some of you, I think, are even employed at the University of Cincinnati. Does anybody who has an affiliation of any kind with the University of Cincinnati feel like that would prevent them from being able to be fair and impartial to both the state of Ohio and to the defendant, Ray Tenzing, in this case? In other words, if you're affiliated in some way with the UC, you can put that out of your minds and again decide this case solely upon the evidence and what happens in this courtroom. Okay. Likewise, I think all of you know at this point that Ray Tenzing is, or was on July 19th, 2015, a police officer with the University of Cincinnati Police Department. He's no longer employed by the University of Cincinnati as a result of the incident that brings us all here today. But is there anybody who has any feelings, pro or con, about law enforcement officers that would cause you to feel like you cannot sit and be fair and impartial to everybody on this case? Okay. Like Mr. Gibson, who read you his jury list, I'm going to run down a few names, and I will tell you that most of the names on our jury or on our witness list are the same names that Mr. Gibson read to you, because you know, it's the same people that know what happened or can evaluated some of the evidence, and if the state doesn't call them, it's likely that we would call them. However, we do have a few other witnesses who will testify, and I'll start off by telling you that probably our first witness will be Santa Ono, the former president of the University of Cincinnati. And he will be testifying by what's called a deposition. he's no longer here in Cincinnati. So before he left, we took his deposition, and that will be played for you on a video disc on the TV that's over there. And I think Judge Shanahan will tell you that his testimony on that deposition or on TV there is exactly the same as if he were sitting in that witness chair. We all agree to listen to his testimony and consider it just as you would the testimony of a witness who came in live and testified. Okay. Another witness who we will call, who I don't believe Mr. Gibson mentioned, or we may call, and just because I name these witnesses doesn't mean necessarily that we will, but we may. Captain Dudley Smith with the University of Cincinnati Police Department, and I'm just going to read these. If anybody knows them, let me know at the end. There's Lieutenant Robert Gutierrez from the University of Cincinnati Police Department. I'm just skipping through the ones Mr. Gibson read. Sergeant Eric Weibel, Police Officer Derek Nolan, Police Officer Jeffrey Van Pelt. They're all UC police officers. Couple Cincinnati police officers, Sergeant Nate Asbury, Sergeant Daniel Carter, Police Officer Thomas Wells. Do any of you know those gentlemen? The other witnesses that we may call, a fellow named Ed Premu, who is a video analyst from Michigan. There is a fellow by the name of James Scanlon, who is a Columbus, Ohio police officer, retired Columbus, Ohio police officer, who is a use of force expert. Anybody know Jim Scanlon? Okay. And finally, the defendant, Ray Tenzing, and you've already indicated you don't know Ray. This case involves the use of a firearm. There were a number of questions about firearms on, not a number, but some questions about firearms on the questionnaire. Is there anybody who has any feelings one way or another about guns that would cause you to not be able to be fair and impartial in this case? Okay. We've already talked about publicity. There's been a lot of publicity. You've all indicated that you can put aside anything you've heard about the case and decide it again solely upon what happens in this courtroom. The media is present today. I'm sure they're going to be present throughout this trial. Judge Shanahan has told you already 2 or 3 times that you're not to watch, listen to, read anything about the case while it's pending. And she's going to tell you that so often that you'll probably be reciting that in your sleep at night. Anybody feel like they will have a problem following that order, not to read, listen to, or watch anything about the case? Okay. The other thing that the judge has told you and will emphasize again, and this is probably going to be a little more difficult. You know, you've probably already experienced this a little bit. You're going to be told that you can't talk about this case with anybody. I mean, that includes spouses, partners, significant others, kids, neighbors, fellow employees. You can't talk about the case while you're sitting here as a juror. And sometimes that's very difficult to do. I'm sure probably you've already experienced it since you were down here last week, and I'm sure family members know you were called for jury duty, and it doesn't take much to figure out what jury you were down here for. People probably inquire. Can you all agree that I won't talk about it? I'll just tell whoever asks, I'm on a jury, I can't say anything more about it. Okay. Here's a question that is kind of from outer space, but does anybody have any strong feelings about either the Ohio Supreme Court or the United States Supreme Court? And the reason I bring that up is that the law that Judge Shanahan is going to tell you that applies in this case, a lot of it has been set forth by the Ohio Supreme Court and the United States Supreme Court. And believe it or not, there are some people who say, well, if the United States Supreme Court says something, I don't believe it. It's wrong. Anybody feel that way? Okay, and again, it gets back to the fact that you'll all be willing to accept Judge Shanahan's instructions on the law at the end of the case. Okay. Mr. Gibson brought up the fact that this case involves a white police officer shooting a African-American man. The news has been full of that kind of stuff lately, and it's a real concern for all of us, because all of us want this case to be fairly tried with people who don't have any bias or prejudice or anything else. This case is not about the color of any man's skin that's involved in the case. It's about the facts. Is there anybody that has a problem, and I know a couple of you folks have indicated both in questionnaires and here this morning, that you think that there could be an issue? Will you all agree with me that you'll decide this case without worrying about anybody's skin color? We'll just do it based on what the facts show. Everybody agreeable with that? Okay. During the course of this trial, Ms. Callender and I have, our job is to represent Ray Tenzing. And we're going to do that to the best of our ability. And at some point during the course of the trial, and we're not going to do it intentionally and don't mean to, but at some point we may ask somebody a question that, and maybe here during voir dire, that you all think is too personal or too aggressive, or we may do something that upsets you during the course of the trial. And again, we're not going to try to do that on purpose. But if we do, can you all promise me that you will hold that against either me or Ms. Callender, but you won't hold it against Ray Tenzing? Okay. Finally, ladies and gentlemen, before I start asking you questions individually, because there are some responses on questionnaires that I think we need to get into, and I assume Judge Mr. Gibson didn't really go into anything individually with people. Should I press on? Or
oh, absolutely.
Okay. Finally, ladies and gentlemen, before I get into individual questions, at some point during the course of this trial, Mr. Gibson or Mr. Dieters or Mr. Pietmeyer is going to announce that on behalf of the state of Ohio, we rest. And that means that they're finished presenting their evidence. Sometimes jurors think, well, if the state of Ohio is finished and they've rested, then it's our turn to rest. But that's not the case. The case is that you've got to keep paying close and careful attention, because we're going to have a turn to go forward. Everybody willing to agree that they'll pay close and careful attention until Judge Shanahan tells you, head on back here and start deliberating? Okay, folks, as you know, you filled out these questionnaires last Tuesday, I guess it was. We got them late Wednesday, and we've had lots of time to go, well, not lots of time, but we've had time to go through every one of them since then. And I think on every one of them, there are questions that we have come up with. Raise some issues that I would like to explore a little bit further. Juror number one, on your questionnaire, you indicated in response, and this is one of the questions I was asking about previously, about do you believe that a defendant in a criminal case should testify or produce some evidence to prove that he or she is not guilty? And you indicated yes to that question. You remember that? Okay. Well, are you willing to accept the proposition that Ray Tenzing doesn't theoretically have to present any evidence? Okay. So, in other words, if he would sit there and not present any evidence or not testify, and Judge Shanahan told you you can't hold that against him, you'd be willing to follow that? And again, on question 120, and this is one that there were some really interesting answers from some people. What are your opinions, if any, about criminal defense attorneys in general? And I found some of the answers amusing, but juror number 1, you indicated that they have to defend their case and prove the innocence of the defendant. Can you accept the proposition that the defendant doesn't have to prove anything in this case? Okay, in this case, a little bit different, because our defense in this case is that what happened here, and as Mr. Gibson, he used the phrase, it's not a whodunit. It is not a whodunit. We know who caused the death of Sam DuBose, and that's Ray Tenzing. We aren't denying that. We're not going to make them prove that. I mean, there's going to be some suggestion that somebody else did it, and we are saying that Ray Tenzing was justified in causing the death of Sam DuBose. So in a sense, we do have to convince you of that. But if we could convince you of that through the state's witnesses, and we didn't present in any witnesses at all, you can accept the proposition that we don't have to actually present witnesses or testimony. Okay. Juror number 2, and we've been instructed not to refer to you by name. Normally when we pick a jury in a criminal case, we are given a one-page questionnaire that you fill out downstairs when you first come in, and we have about a half hour to look at those, and then we get up here and we question you based on that, and we kind of, I usually address you by name, and we're not doing that today for obvious reasons. But sometimes I hope I don't slip up, because I just about did it with you, juror number 2. I read your name on here. You've indicated this morning that, number 1, that you could not be sequestered. And I want to make sure everybody knows, it's not automatic that you're going to be sequestered. The only way you would be sequestered is if we finish the testimony, and Judge Shanahan instructs you on the law to apply, and you go back and start deliberating, and it takes you a long time to reach a verdict, and you can't do it in the same day you get the instructions, and you're going to have to come back. You would be sequestered for however many nights that it took. So there's no absolute written in concrete that you're going to be sequestered. But juror number 2, you indicated that sequestration could be a problem for you.
Yeah, this is what it works.
Okay, well, I mean, I think that's probably, I think I can go out on a limb and say it's probably the same for everybody in this room. I mean, if you got to sit on this jury, I mean, would you just, it's not like you just walk away and say, I'm not going to be sequestered, is it? Okay. Now, you also indicated that you had feelings about this case, and especially based on some movie that you apparently just saw, that would make you unable to set aside your feelings about what the outcome of the case ought to be. Is that correct?
I think it's difficult. I think everyone has an opinion on this case. The murder that occurred, for most of us out there in the city.
Well, and that's what the purpose of this whole process here is, to try to find, I mean, everybody's got opinions about everything, but in this courtroom, our goal is to find 12 people who may feel, and the thing is that nobody has heard all the evidence. In fact, I don't think anybody's heard any of the complete evidence in this case. And so the objective here is to find 12 people who will say, I've read about this, heard about it, I've got an opinion about things, but I'm willing to put that aside, and I will decide the case solely upon what happens in the court. You think you could do that?
Yeah, I think it's doable. It's hard to say that too at the same time.
Okay, I mean, you said, I think, that you weren't sure you could sign a verdict because of the political climate.
Right.
I mean, is that something that you feel is I mean, are you concerned about that for your personal safety, or because you have to go back and face friends or family, or?
No, it's just personal views.
Okay. And are your personal views so strong that you don't think you could be fair either to the state of Ohio or to Ray Tenzing?
I would agree with that. I could agree with that. It would be difficult for me to be there.
Okay.
You have personal experiences out there, and some situations that make it difficult for me.
Okay, fair enough. And that's, I appreciate your candor, because that's exactly what we're looking for. Would you rather not sit on this jury? Okay. Okay. Juror number 4. You indicated that you've sat on a jury before, and I think you told us that this morning, if I recall correctly. No? Okay. Were the jury, well, first of all, were those in Hamilton County? And do you remember, were they criminal cases, civil cases? Okay, and that's probably in your questionnaire here, but I didn't note that. Did you, without telling me what the result was, did the jury reach a verdict in those cases? Was there anything about that experience that caused you to feel like, I don't want to come back and do this again? Okay. And will you, I'm sure that, again, I talked about reasonable doubt before. I'm sure that the judge in those cases read you the definition of reasonable doubt. And I have no doubt that the judge read that definition to you correctly, but will you forget about everything you learned in those cases and decide this case based solely on the law that Judge Shanahan will tell you? Okay. One of the questions on the questionnaire dealt with, do you think police are selective in who they stop for such minor violations? And you checked yes, and then you wrote down there, more likely to pull over poor and minorities. Is there anything about your feelings that way that make you feel like you're biased against police officers? Okay, and you can, in spite of your belief, you'll again, and I'm going to keep harping on this till everybody's tired of it, you'll agree to be fair to both the state of Ohio and to the defendant. Okay. Juror number 6. You indicated on your questionnaire that you've also had prior jury service about 10 years ago. Are you also willing to put aside anything you may have learned about the law or about the criminal justice system and decide this case based solely on what happens here? Okay. You also indicated that you have lived next door to a Cincinnati police officer and you've discussed it with that officer. Is there anything about those discussions that would cause you to feel you couldn't be fair and impartial to both parties in this case? Thank you. Juror number 7, we've already talked about your potential problems, so I'm not going to belabor the point. So don't feel slighted if I don't ask you anything. Okay? Juror number 9. One of your questions on the questionnaire, you indicated that you didn't think law enforcement officers should enforce speed limit or stop sign violation laws. You remember that? I mean, do you, and I'll tell you right now that this case, you indicated, the question was, do you think police are selective in who they stop for such minor violations? You checked yes. And then it said, if your answer is yes, how do you think police are selective in these stops? They can stop you for speeding and not give a ticket. Let me make sure I'm looking at the right one here. I am. Okay. And you indicated that you thought law enforcement officers target African Americans for arrest and ticketing. Remember that? Okay. Again, can you set, and I'll tell you up front, that this case, and if you don't know, and theoretically you shouldn't know, but everybody's heard and read about it, the premise was put out there that Ray Tenzing stopped Samuel DeBose for not having a front license plate on his car. I would say that probably is not as serious in the overall scheme of things as running a stop sign or speeding. And there will be, and a lot of people will feel that that was a minor violation he shouldn't have stopped him for. And I'll tell you right now that the evidence will show that that's not the reason, the primary reason that Ray Tenzing stopped Samuel DeBose. But it was a more serious situation than that. Will you, in spite of your feelings, be able to sit and be fair and impartial to everybody in this case, or do you have such strong feelings that you can't sit here? Okay. And I'm not trying to pick on you or anything, but you know, some of these questions elicited answers that I think we need to explore a little bit. Number 10, Mr. Bono. Is it Bono or Bono? I did it. Judge, I apologize.
It is. We'll address it.
Sir, you have indicated that, I think a couple places here, that you have an opinion on this case already. Is your opinion so strong that you can't change it? Okay. I mean, and I'm not saying you, I just wanted you to say I'll be neutral until I've heard all the evidence in this case. Can you do that? Okay. I mean, again, you indicated in a whole series of questions that you have an opinion that you could not, you indicated you could not sign a not guilty verdict. You might have difficulties following the instruction not to talk to people. Let me look here. I made quick notes, so I may have made them wrong, but okay, I apologize. That one says it says, will you be able to follow that instruction, or will family and friends that learn you are a juror in this case make it difficult? You wrote no, and all I did was read the first part of the question, will you be able to follow that instruction? It's actually two questions in one. So I assume maybe that your answer no was family or friends learn you are a juror in this case will not make it difficult for you. Is that correct? Okay. You also indicated that you have two relatives who are Cincinnati police officers. Okay, do you ever discuss with them police work or what they do? Is there anything about your relationship with them that would cause you any difficulty sitting on this case? Okay. Juror number 11. Okay, I'm going to rein in my automatic response to refer to you by name. You've indicated that you know Shannon Hine, correct? And I think that you indicated to Mr. Gibson that despite the fact that I think you said you know her from Kroger's and from Bingo, maybe? Yeah. Okay. You've indicated that you can put aside your relationship with her and decide this case based solely upon what happens in the courtroom. Okay. Is there any other reason that you don't think you could serve on this jury if we ask you? Okay. Okay. Juror number 13. Your questionnaire raised a lot of questions with me. You indicated that you have an opinion already about this case, correct? Right now, okay. So, I mean, again, if I'm hearing you right, you're saying that I have an opinion, but that opinion is not going to affect me in my ability to sit on this case, and I can set that aside and decide the case solely upon what happens here? Okay. You indicated that you would not sign a not guilty verdict if the evidence called for it. Okay. I'm not telling you to sign guilty or not guilty, but if you flat out said I would never sign a not guilty verdict no matter what the evidence is, then you couldn't serve on this jury. You don't meet the fair and unbiased and impartial test. You understand that? Okay. In response to the will your feelings you have after having seen the video influence your ability to be fair and impartial juror and base your verdict solely on what you will see and hear in court? You said yes, that the video would affect your ability to be fair and impartial. Okay, but I mean, again, after you've heard the questions that we've been asking this morning, I think you probably understand what we're talking about. We want people that'll just base their decision in this case based on what happens in the courtroom, and you're willing to do that. Okay. Number 14. Notice you've had that coat up and down. It's a little cool in here. I don't know if we have any. I don't have any ability to control that, so don't hold that against me. Okay. From looking at your questionnaire, you were probably one of the few people who claimed to have absolutely no knowledge of this case. Is that a fair statement that you don't? Okay. Based on what you've learned about it so far in this courtroom today, is there anything that causes you to feel that you couldn't be fair and impartial? Are you willing to sit on the jury if we ask you to? Okay. I'm getting all out of order here.
Take your time.
I'm out. Okay. Juror number 16. Juror number 16, you indicated you've had prior jury service. And again, like I asked the others, would you be willing to forget about anything you learned on those juries? Is there anything that's happened so far today that causes you to feel that you don't want to or can't sit on this jury? Okay. One thing that caught my eye on your questionnaire was you indicated there were two questions. Can you, I'm going to paraphrase, can you sign a guilty verdict? Can you sign a not guilty verdict? And you wrote yes to both of those, but next to each one you said, I think so. And then you crossed I think so out. Was there any significance to that?
Originally I wrote I think so, and then I crossed it out and said that I could sign based on one way or the other.
Perfect.
Admittedly, it is a very, very important decision, and took a little bit of soul searching during the questionnaire to get onto that.
Well, I'm sure that was probably the same feeling everybody that filled that questionnaire out had. But again, we need people that don't have any doubts about their ability to serve on this jury and be fair and impartial. So the I think so is gone. You can do what you're asked to do if we ask you to sit here, correct? Okay. Juror number 17. Has anything happened here so far that causes you any problems this morning? Okay. I'm thinking from your questionnaire there wasn't anything that caused me anything I want to follow up on. You can be fair and impartial to everybody, correct? Okay. Then juror number 20. Okay. I can't remember. You indicated something this morning. I think I wrote down. Oh, you know Mike Trimpe from the crime lab. And I think you said there was nothing about your relationship with Mr. Trimpe that would cause you any difficulty in sitting on this case? Okay. Is there anything that you feel would cause you any problems here?
No.
Juror number 21? 19? Aha. There we go. The only thing from your questionnaire that caused me concern was you indicated on there that I assume you're a teacher? And you indicated that you have to give, I guess those are the state mandated tests to third graders. My law partner's wife quit teaching as a result of those state mandated tests. But you indicated those are from November 14th to the 18th, correct?
Correct.
And again, as I've indicated, and as we've all indicated, I don't think this case will go that long, but we've all tried enough cases in our careers to know that sometimes things happen and it could go that long. If you were not available, would that create a great problem, or could somebody else pick up?
After it was brought to my attention, I went back to school and we became really able to cover the second position. The circumstances are because I'm responsible for IEP children.
Okay. But that's taken care of. Okay. Is there any other thing, anything I've asked or Mr. Gibson asked that causes you to feel you couldn't be fair and impartial if we asked you to sit on this case? Thank you. I have nothing further, Judge.
Thank you very much. Ladies and gentlemen, it is now 12:10. This is probably a good breaking point for lunch. We will be providing you lunch today back in room 580. So I'll have Mr. Knoll deliver you back to 580 to have your lunch. Do not discuss this case among yourselves. Do not allow anyone to discuss it with you. Do not form or express an opinion about this case. Enjoy your lunch. I'll rise for the jury. Very good. Council, let's go in chambers for a few minutes. What's that? You may, like the rest of the ladies in the room.
You'll be up there.